What does civil rights actually mean? When we discuss civil rights, we are actually talking about equality under the law. Civil rights and privileges are guaranteed by the government under the Equal Protection and Due Process Clauses of the Fifth and 14th Amendments. These rights are based on the premise that the government should protect people from any and all discrimination, which results from what they call inherent characteristics. What are inherent characteristics? Those are individual characteristics that are part of a person's nature, such as race, religion, national origin, and sex. The Constitution imposes constraints, which are civil liberties, and responsibilities, which are civil rights, on the government. Like civil liberties, civil rights are not absolute. Civil liberties are protections from the government. They are liberties that are given to our citizens that the government cannot constrain. On the other hand, civil rights are the responsibilities of government to be sure that our citizens are not discriminated against based on any of these inherent characteristics. Today, the court uses three tests to determine when unequal treatment is legal: strict scrutiny, heightened scrutiny, and ordinary scrutiny. Courts view race, ethnic origin, and religion to be suspect classifications. Under strict scrutiny, it says that discrimination is legal if it is necessary for the government to achieve a compelling national interest. For example, at one time, interracial marriage was prohibited. The Supreme Court eventually ruled this alleged offense unconstitutional because there were no compelling interest. The government must show that the differential treatment is necessary for it to achieve a compelling public interest for which it is responsible. And in the case of the interracial marriage, they were not able to demonstrate that. Under heightened scrutiny, this is typically used in sex-based discrimination cases. Government must show that sex-based differential treatment is substantially related to an important public interest for which the government is responsible. Under ordinary scrutiny, or the rational basis test, it says that on the basis of this test, sex-based discrimination is legal if it is a reasonable means by which the government can achieve a legitimate public interest. The idea of suspect classifications means that when courts view race, ethnic origin, and religion, the judges will further assume that the laws treating people different are unconstitutional. Discrimination is not always on a grand scale. This type of discrimination can be conducted by individuals. As an example, the Me Too movement reminded victims that they are not alone. The results of this were increased reporting of inappropriate sexual pressure or violence. Slavery and its aftermath. When it was first written, the Constitution implicitly endorsed unequal and discriminatory treatment of African Americans. Although the movement to abolish slavery was in its early stages in the year the Constitution was completed, by the early to mid-1800s it had gained significant momentum in the North, largely because of the activism of various religious and humanitarian groups. Most African Americans are descendants of slaves. In 1619, the first Africans arrived as indentured servants, and these are workers that said they would work for a certain period of time in return for their passage. By the mid-1600s, slavery had begun to replace the indentured servitude model. As people moved west, those who opposed slavery were actively engaged in civil disobedience. They did not comply with laws they found morally objectionable. Operators of an underground railroad, which was a way of sneaking slaves out of their enslaver into northern states or even Canada. However, Fugitive Slave Act of 1850 required the return of runaway slaves. This created a system of bounty hunters or people who would capture slaves and return them to their owners for a fee. Uncle Tom's Cabin was a book by Harriet Beecher Stowe that spoke of the terribly harsh treatment of the slaves. As a result, more advocates began to oppose slavery and were mobilized. Because at that time, African Americans were not considered citizens of the United States. They have no rights of citizenship, such as voting, being landowners, or the right to sue others in a civil case. Nonetheless, slavery, with all its horrors, continued and eventually was the precipice for the Civil War, which began in 1860. It was at this time that the Southern states decided to secede, and a long and bloody war followed. With the Emancipation Proclamation, slaves were freed and became citizens in their own right. Most importantly, several constitutional amendments confirmed this stance. First was the 13th Amendment, which was in 1865, and this one ended slavery throughout the United States and prohibited it in the future. The 14th Amendment was 1868, which we have discussed several times, and it gave everyone equal government and legal rights to the protection offered to the full extent of the law. It's commonly known as the Equal Protection of the Laws Clause. And then the 15th Amendment, passed in 1870, decrees that every man has the right to vote, regardless of their color. The Reconstruction Era was a time of the rebuilding of the institutions and infrastructure of the South from 1866 to 1877. At that time, former slaves or freemen had significant voting leverage. Something called black codes were intended to limit the rights of the recently freed slaves. Various civil rights acts made it a crime to deny people their rights and privileges as citizens of the United States. So there were laws that were passed to negate these black codes. First, we had the Civil Rights Act of 1866 and the Civil Rights Act of 1872. Then we had something called Jim Crow laws. Jim Crow laws actually just returned the African Americans back to their pre-slavery days, where numerous roadblocks would impede them from voting. Essentially, it ensured ongoing segregation. Jim Crow laws required the strict separation of racial groups. De jure segregation legally mandated separation of the races, and it became the norm in much of the South. And then de facto segregation, in fact, if not in law, manifested in the North in housing, employment, and education. State and local governments in the South also found ways to prevent African Americans from exercising their right to vote. In the white primary, this meant that in the primary election, which would be your first election, only white men were allowed to vote. Then they applied the literacy test, and you had to pass a literacy test in order to vote. So for decades and even centuries, it was against the law for African Americans to be taught to read. So obviously they would not be able to pass this literacy test. Then there was a tax levied. It was known as a poll tax. And it was levied in order to you had to pay it in order to vote back in 1902. This tax amounted to about $1.50 or $2. Now, that doesn't seem like very much, but for the poor in 1902, it was insurmountable. The grandfather clause said a person would be exempt from the above test if they had been eligible to vote prior to 1870. Of course, most African Americans were still slaves up to that time, so they were eliminated. These Jim Crow laws were enforced by both government agents and non-governmental groups such as the Ku Klux Klan. A Supreme Court case in 1883 said that Congress lacked the authority to prevent discrimination by private organizations and individuals and declared the Civil Rights Act of 1875 unconstitutional. In 1896, the Doctrine of Separation, or of separate but equal, was created, which declared that to separate facilities such as those for eating, transportation, seating, and going to the restroom that did not violate the 14th Amendment Equal Protection Clause. This is represented by the Plessy versus Ferguson ruling. Plessy was a 1/8 African American who boarded a railroad car designated for whites only. He was asked to leave the whites-only car, and he refused. He was then arrested and jailed and charged with violating the state law. The Supreme Court shot down the argument and said that segregation based on race was not a violation of the Equal Protection Clause. In essence, this created the separate but equal doctrine. This graphic shows the racial nature of lynchings in the United States. Now, the source of these data defines lynching as a ritual murder of one or more people by a group of at least 3 people outside of the legal process. So this means that there was no trial, but people were lynched based on nebulous evidence, shall we say. If you see that the states of Mississippi and Georgia between 1882 and 1968 had the most lynchings, or near the most lynchings, and the green states would be where there were no lynchings. In spite of the passage of the 14th Amendment, known as the Equal Protection of the Laws Clause, African Americans still struggled to gain equal protection in the early 20th century. There were some small successes in the early 20th century because the political climate became open to reform, since there were so many activists seeking reform. However, this took decades to bring to fruition because by the early 1950s, activist groups began to argue that segregation itself was in violation of the 14th Amendment. And in 1954, the Supreme Court ruled that the separate but equal rule, which had heretofore been relied upon, was indeed unconstitutional. There were several groups, including the NAACP and the Civil Liberties Union, which have been successful in eliminating discrimination because it was unconstitutional. In 1954, the Supreme Court ruled in Brown versus the Board of Education of Topeka that segregated schools violate the Equal Protection Clause of the 14th Amendment. Brown versus the Board of Education of Topeka is a landmark case that precipitated societal change. In 1955, some said that Emmett Till, a young teenage African American, made inappropriate comments to a white female and was kidnapped, tortured, and killed. Also in 1955, in Montgomery, Alabama, the bus driver asked Rosa Parks to give up her seat for a white man, and she refused. This situation was considered a test case to challenge the constitutionality of segregation. Martin Luther King mobilized a bus boycott based on this case, and the city lost large amounts of money. In 1956, segregation was ruled unconstitutional. If you ever have an opportunity to hear Dr. King speak, you should do that. He was by far one of the most passionate and inspirational speakers in history. The Civil Rights Act of 1964 mandated equality on many fronts, including employment, public accommodations, including hotels, restaurants, and theaters, plus public facilities, which I suppose means bathrooms, There was a lot of resistance, particularly within the schools. This act allows the federal government to sue any school which was not segregated and force it to desegregate. As the movement gained momentum, a voter registration drive in 1974 yielded over 250 new registered voters. This was the precipitous for the riots in, for example, Mississippi, because activists came into the South and for the express purpose of registering voters. An added bonus to the Voting Rights Act was that more African Americans began to run for local office. Today, Southern states are among those with the highest number of African Americans holding local offices. However, statewide, anything higher than a local office has not enjoyed the same success. Mississippi, for example, has not had a statewide African American elected official since the Reconstruction. Additionally, because of its success, the civil rights movement became the model for political engagement. The Black Lives Matter movement came as a result of the killing of a young African American male, Michael Brown, in Ferguson, Missouri. Even though the Department of Justice ruled the shooting of Brown was justified, the long history of state-sanctioned violence was uncovered and brought to the forefront of people's attention so that we could all see that the violence against African Americans, which was now long-standing, treated Black citizens as though they were of lesser value. Though the long-term and ongoing success of specifically Black Lives Matter is questionable, it has resulted in rethinking of strategies and training for police in their interaction with communities of color and brought about new policies regarding such things as body cameras and specific protocols to use during potentially violent situations. Trying to precipitate broad social movements with such a splintered agenda only dilutes the real purpose of future movements. It blurs the goals because the agendas now lack clarity and they are competing policy positions and needs. Counter-protests become little more of a challenge to law enforcement as opposed to any real constitutional policy outcomes. In equity, however, equity is a process and equality is an outcome. Without equity, you cannot have equality. Equity is a way to even out opportunities. Equality means the provision of the same resources to all people. It is a state of being the same. Equity is about justice and fairness. Equality is the state of everyone being at the same level. Concurrently, but not as successfully, women had been advocating for equal rights, as well as the constitutional foundation of being able to vote. During the drafting of the Constitution, Abigail Adams told her husband John Adams to remember the ladies in their document, because women would not support any document in the long term that did not include them equally. In 1848, at a conference in London, something called the Declaration of Sentiments, which called for immediate admission to all rights and privileges which belonged to them as citizens of the United States. Since the Constitution originally deferred to the states, the determination of who had the right to vote, women had to begin their battle at the state level. The social norms for women during this time were to be a good wife and mother, and most women were economically dependent on others, typically their husbands. In one Supreme Court case, it was found that women's God-given destiny was to, quote, fulfill the noble and benign offices of that of a wife and mother, and changing the law otherwise would impinge on that destiny. Women did not choose a career typically. Women who did choose a career typically gave up the idea of having a family. This was not a legal thing. It was just the result of societal pressure. Even then, the career choices were limited. When I grew up, it was socially acceptable to be a working woman, assuming your career choice was a helping profession, such as a teacher, a nurse, or some religious-based vocation. Finally, in 1920, the 19th Amendment was passed and women gained the right to vote. The 26th Amendment changed the voting age to 18 or older. After the passage of the 19th Amendment, women's activist activities died down. Not until the 1960s was there remobilization of this movement. As the divorce rate grew and women's positions in the home changed, more women entered the paid labor force. Also, there was a huge societal shift at that time to an anti-traditionalist sentiment. As the women realized that they had been stiffed in their rights, such as employment, credit and banking status, and educational opportunities, it became apparent that they were not equally protected under the laws. The Equal Pay Act of 1963 enacted into law that employers were prohibited from paying women less than men were paid for the same job. This gender gap continues even today. Title VII of the 1964 Civil Rights Act was broad, but eventually was narrowed to prohibit discrimination in all personnel decisions based on sex, as well as the other inherent characteristics typically applied to acts of discrimination, such as race, sex, and so forth. Women knew the need to pursue educational opportunities on the equal basis as men. So because education is not specifically mentioned in any of these acts, women knew they had to further address their rights to education. Thus, Title IX of the 1972 Amendment to the 1964 Civil Rights Act prohibited sex-based discrimination in educational institutions receiving federal funds. Basically, this third wave focused on recognizing that women have unequal access to legal rights owing to differences in race, class, ethnicity, and religion. This is compounded by the concept of intersectionality, on that of experiencing multiple forms of oppression simultaneously. This happens when overlapping and interdepending systems of discrimination or of disadvantage are created. So an example of intersectionality would be a woman that is an African American. So there would be discrimination based on the fact that a person is female. There would be additional discrimination based on the fact that the person is also an African American. As human rights have expanded more, those with the alternative or counter-traditional sexual preferences and identities have organized and fought for equal access to employment, housing, benefits, and marriage. About 1.4 million U.S. citizens identify as transgender, or more specifically defined as those with fluid identities because they do not identify with either male or female, have advocated for legal protection for years. A lot of unreported hate crimes happened to this population. In 1969, the first hate crime law was enacted. This was subsequently expanded into part of the inherent characteristics. A hate crime is a crime that is motivated by one's bias against the victim as perceived via their inherent characteristics. Intersectionality plays a part in this as well. The Stonewall Rebellion of 1969 was a rebellious clash between gay and lesbians and the New York City police against the police's ongoing harassment, bias, and discrimination of their community. Both of the cases, Bowers versus Hardwick in 1986, which upheld the anti-sodomy laws, and the Lawrence versus Texas 2003 case, which overturned the Bowers decision, and the Supreme Court ruled that people have a right to their preferred sexual activities without interference into their sexual and intimate privacies. The LGBTQ community is still waiting for a federal law prohibiting LGBTQ-based discrimination in the workplace. EEOC rules are limited in this protection. What are the issues of same-sex marriage? Marriage allows one to enjoy certain important rights. First of all is the right to inheritance. Then rights to government as well as other employment types of benefits, hospital visitation rights, as well as the next of kin identity can become its own life-identifying situation. Through a series of decisions in 2015 in the Obergefell versus Hodges case, the Supreme Court found that the right to marry is a fundamental liberty and is protected by the 14th Amendment. Native Americans had no rights to U.S. citizenship until 1924. They were considered citizens of whatever nation under which they lived and believed according to the treaties signed between 1778 and 1870. The struggle for the rights and liberties of the Native Americans continues. One of the biggest challenges they have is health care and education. Their educational opportunities are abysmal. Their K-12 schools are on their reservations, are poorly funded, and do not provide a comprehensive worldview that qualifies education, that quality education should avail to everyone. Citizens of Latin descent, or Latinos, though we tend to think of them as Mexican Americans, are actually from many countries, both in South and Central America, as well as the Caribbean. They are the largest minority group in the United States and represented over 17% of the population. Of this population, 65% are native-born Americans. Typically, they have lower voter turnout than other minorities. Therefore, they are not heard nor attended to. The U.S. declared war against Mexico in 1846 because of land disputes. By 1848, a treaty was drawn up but left Mexico, ceding the land to the United States. LULAC, or the League of United Latin American Citizens, was a group organized in 1929 to advocate for the rights of Latinos in the United States. Just as was the case for African Americans in certain states such as California, there were segregated schools so that Latinos were designated specifically to Latino schools. LULAC filed suit and was able to get schools desegregated in this landmark California case. Chicanos are specific to Mexican American Latinos, and their movement focused on equal employment and educational opportunities. Cesar Chavez was a community organizer in 1952, which encouraged the Chicago community to exercise their voting and civil liberties and rights specific to their discrimination against community. He was an integral part of improving working conditions and pay for many migrant workers in our country. With 11 million undocumented immigrants in the United States, in 2003, ICE, or the Immigration and Customs Enforcement, was created for the enforcement of immigration laws. Originally, only convicted felons and those considered a safety threat could be or would be forced to leave or be removed. Nonetheless, shortly after Trump's election, he expanded the ground on which a person could be removed. In 1 year, this expanded the deportation to 226,000 individuals. How do we address illegal immigration? We can implement mass deportations. We can ease the path to citizenship for families with children born in the United States. We can provide some type of temporary reprieve or safety for people without a pathway to leadership. We can provide refugee status to unaccompanied minors fleeing from their home countries. Asian Americans represent their own microcosm of diversity because of their various cultures, religions, history, and languages. Certain civil rights have been formed to support their cause. At first, they were not allowed to become citizens, but in 1952, that gate was knocked down to allow them to cross over into citizenship. During World War II, there were approximately 120,000 native-born Japanese U.S.-born citizens, and about two-thirds of them were put in prison camps and relocated onto the West Coast. Often they lost their homes and businesses. Through decades of activism, in 1987, a $1.2 billion provision was made to them in reparation. The Americans for Disabilities Act, or the ADA of 1990, defines a disability as any physical or mental impairment which that substantially limits one or more of the major life activities of an individual. The ADA was amended in 2008 to broaden the definition of what substantially limits major life activities actually means. What is affirmative action, and is it constitutional? That is, in the context of allocation of resources or employment, the practice or policy of favoring individuals belonging to groups known to have been discriminated against previously in the context of allocation of resources or employment. The practice or policy of favoring individuals belonging to groups known to have been discriminated against previously. Affirmative action is a type of equity delivery. It started with the government trying to normalize the treatment of minority men in employment positions. Eventually, this led to and was extended to others through education and other employment opportunities. Affirmative action is intended as a remedy for prior unlawful discrimination. Although, like many of our systems intended for good, it is flawed, but it does tend to create more level playing fields for minorities and helps to foster American meritocracy. What are the disadvantages of affirmative action? It promotes discrimination in reverse. It still reinforces stereotypes. Diversity can be just as bad as it can be good. It changes accountability standards. It lessens the achievements that minority groups obtain. Then, African Americans, women, Native Americans, Latinos, and other groups struggled to achieve equality in the United States. And now, women are challenging current and historic sexual harassment and assault as a violation of civil rights, changing understandings of gender identity and sexual orientation are altering our definition of civil rights. Communities of color are protesting abuses from law enforcement through the Black Lives Matter movement. What protections will the nations be willing to extend to undocumented immigrants and their children? Will access to safe drinking water and water rights become the next front in the civil rights battles? And should quality, affordable housing and childcare be considered a civil right?